before speaking to Hansard, but he meant well. He meant well, Mr. Speaker. He had actually come to me reading the memorandum accompanying the bill, and raised that technical concern. So, Mr. Speaker, I think it's more about the approach. But you also know that, Mr. Speaker, sometimes in equity, form gives way to substance. Form gives way to substance. So he's sorry if he created that impression. But Reverend, Mr. Speaker, Reverend will never, Mr. Speaker, Reverend will never disrespect you. He will never do that. So please, Mr. Speaker, let's
I don't know how the chamber was created. When you are sitting here and people speak, you hear. So when I heard it, advisedly, I said you can come and seek my guidance outside. Because when you debate the principle accompanying a bill, a second reading, and the bill has passed that stage to a consideration stage, you don't raise any issue about the principle. It is not done. I would have taken it lightly if it is a backbencher. But he is a senior man of the house. So advisedly, when I'm telling you, come and engage me outside, you would have taken a cue. And I even went further to say that if what you are going to raise is a matter that ought to have been considered a second reading, then I don't urge you to raise it. Where on earth, in which democracy, will you pass through a second reading stage of a bill, yet there will be a guidance seeking on the principles accompanying the bill? Honourable members, let's all do the right thing and let's take a cue where we are supposed to take a cue. For me, I can be undermined, but posterity will be the judge. Yes. Let me hear you, Majority Chief Whip. Yes.
Speaker, it's our duty to help you maintain order in this house. Speaker, the minority leader is called to order sometimes. The majority leader sometimes also called to order. As for the whips, we get it often. So I am worried that we must call attention to it. This is not the first time. The Honorable Ntimfojo couldn't have left the chamber throwing his arm towards the speaker and walking out. He cannot do that. This is not the first time. He cannot do that. The cameras will bear us out. He can't be leaving the chamber and throw his left arm at the speaker. The speaker presiding is the speaker presiding. He left the chamber and came back to gather his books. It's unacceptable. It's a disorderly conduct. And we must call him to order. It's not the first time. It's not right.
Honorable
it is not
Majority
right.
Chief Whip.
So I will leave it here.
Yes, Honorable Majority Chief Whip.
It's improper.
Honorable Majority Chief Whip.
Speaker.
It's been said that to err is human.
Mr. Speaker, thank
you.
To
forgive is divine. Sometimes I believe strongly to forgive can be diabolical. But in the circumstances, I will just let it go and then we make progress. So let's make progress.
Speaker, in the circumstances, we pray that we call motion number 21, Mr. Speaker.
Yes.
Speaker has pronounced on the matter.
Yes, indeed, that he's made a general pronouncement to end the matter. But Mr. Speaker, this is a House of Records. My colleague did not leave the chamber throwing up his hands in disrespect.
Honorable Minority Leader, I beg you, don't go there for us to ask that the video be shown. So
Mr.
please,
Speaker, let me finish.
let's end it.
Mr. Speaker, let me finish.
Let's end it here.
Mr. Speaker, let me finish. You've spoken. You have spoken. You always call on others to listen to you in silence. You've spoken. Mr. Speaker, the colleague left and engaged the chair of the Security and Intelligence Committee. Mr. Speaker,
So, honourable members,
Mr. Speaker,
let this bring us to the end of the consideration stage so that they can till the meat. For now, we come to the end of consideration stage of the Security and Intelligence Bill 2025. So, Masha. Minority Leader.
Mr. Speaker, the chief whip of the majority caucus is moving this house to consider the motion number 21. I must draw his attention to the absence of the Attorney General as well as his deputy. This is a new legislation that deals with professional legal education. Mr. Speaker, the minister or his deputy should be here. I would therefore humbly pray that we suspend proceedings on this, look at other items that we had agreed upon at conclave, and deal with them whilst he makes the effort to call either the Attorney General or his able deputy to come in here, because, Mr. Speaker, he must give direction when it comes to the principles and the policy rationale on this bill. In his absence, we cannot make any serious progress on this, Mr. Speaker, and we all know that the practice has always been that when such bills are being considered, the sector minister, and for that matter in parliamentary language, the sponsor of the bill, must be present to guide, to lead, and to be part of the entire process. Mr. Speaker, I rest my case.
Yes, let me hear from the majority chief whip.
Speaker, first of all, there's no requirement that at consideration stage the minister must be here before consideration can be had on the bill. It's a protocol we have followed. That is why, in the absence of the minister or sponsors of the bill, the main sponsor, a deputy minister, is often admitted to participate in the consideration. I would have agreed with him if we were debating the principles, but we have moved long past that. In any case, Mr. Speaker, I have reached out to the minister, the Honorable Attorney General. He's indicated that he will join us in no time. Yesterday we did it, he joined us sometime and left, and we continued. So, Mr. Speaker, I want to plead with the minority leader to disengage and to let us proceed and the Attorney General will come and join us. The chairman of the committee and his able vice chair are ready. The committee members are here. Members of the House are also here. Both sides, we are ready to do this. So, Speaker, I want to urge the minority leader to drop his point of litigation so that we can make progress in this matter. I thank you for the opportunity.
Yes.
Mr. Speaker, according to the majority chief whip, there is no such requirement for a sponsor of a bill to lead the enactment process. Again, he argues that there is no such requirement for the sponsor of a bill to be part of the consideration stage, and that the absence thereto is inconsequential. That is what he's telling this House. Mr. Speaker, I do not want to be part of such a bad precedent, and this side of the House won't be part of such precedents. Yes, Mr. Speaker, we have a sector minister. This is not a bill that is coming for a mere amendment of 2 or 3 clauses. It is a new bill introducing a new concept for professional legal education, and all that the majority chief whip has to say to us is that there is no such law. So he has cited some members. Read the rules when the bill is introduced. Mr. Speaker, if you read the provisions in our standing orders, right from the start of the bill being introduced, the name of sponsor is mentioned. The sponsor shall. Who is the sponsor? There is no need to repeat the sponsor at the consideration stage, because by parity of reasoning, you look at the mention of the phrase in other provision and conjoin and give it effect. So, Mr. Speaker, what is the majority chief whip trying to say? We need the minister or his deputy to be here. He must be here. And Mr. Speaker, there is no rush. If he himself says he has called him, he should tell us where the minister is. If you'll be able to come, we should know. It is past 6. We have other business. I think I've seen my colleagues in the energy committee. They told me that they have a motion. The report was distributed yesterday or so. If you are ready, we can look at it whilst waiting for the Attorney General. Mr. Speaker, the Attorney General must find time for Parliament, especially when this bill is his bill.
Honorable Minority Leader, with all due respect, Parliament is a place of record. The record of this House will show that as in minority, I have ever shepherded a bill by moving amendment as a minority member without the presence of the minister and the chairman of the committee. So this is not the first time a bill will be considered when the sponsor or the minister is not at the chamber. But the record will bear me out that again, we have shepherded a bill throughout the consideration stage without a minister, and when we got to the third reading, the minister indicated that owing to the volume of amendment to the bill, she is not coming to move the third reading of the bill. But this House agreed with the then majority leader that he should go ahead and move the motion for the third reading of the bill. That has been done. So for me, it will be very novel to say that because the minister is not at the chamber, Parliament sees with the jurisdiction to do consideration of the bill, will not do the consideration of the bill. So that parliamentary work regarding passage of law should be at the behest of the minister. When the minister decides not to come, then it means that the work of Parliament must stall. So with all due respect, by practice, we are masters of our own rules. So I have seen it happen severally in this house. And myself, it's a test case. Moving an amendment as a ranking member in the absence of the chairman, the vice chairman of the committee. And the passage of law, I did that because passage of law have no respect for a political party. The law governs the entire nation. If this bill is not passed timeously, in the academic year, our children will have to go through the process of writing examination in order to enter the law school, backlog of cases. But this bill is providing a mechanism that you go to do it and you write the bar exams. So it is in the interest of the public to do this, but not to tie it down to a minister.
Speaker, if I may assist the House further. Speaker, Order 169, Rule 1 is to this effect, with your leave. When a bill has been read a second time, the bill shall pass through a consideration stage in the House, which shall ordinarily not be taken until at least 2 sitting days have elapsed. Speaker, Rule 3 of Order 169 is to this effect. At the consideration stage, A, the maid shall stand tilted before the table, and a member may speak more than once to any question proposed. B, a member may sit at any seat convenient for the purpose of participating in the consideration stage. C, the House may effect such amendments as the House considers necessary, except that the amendments including new clauses and new schedules shall comply with the following. I, the amendment must be relevant to the subject matter of the clause to which the amendment relates. I, the amendment must not be inconsistent with any clause already agreed to or any decision already taken by the House. And I, the amendment, if not intelligible without a subsequent amendment, notice of the subsequent amendment will be taken. So, Mr. Speaker, there's no requirement. It's just by practice. So for the minority leader to insist that until the second minister is here, business cannot be conducted at consideration stage, is actually in breach of the law, of our procedure. He must desist from his insistence, because his insistence is not borne out by the rules.
No, he is not insisting. He is amenable.
Mr. Speaker,
leader, you are amenable.
Mr. Speaker, I'm guided.
Mr. Speaker, you put it right, and I appreciate that. Mr. Speaker, but let the records reflect this, that if indeed this bill has any urgency, then it is expected that the Attorney General must give it attention by being in this chamber. Mr. Speaker, it is not as if the argument is that in the absence of the Attorney General, Parliament cannot do its work. That's not what I'm saying. What I'm saying is the Attorney General, being the sponsor of the bill, must be here to shepherd the process. Mr. Speaker, he is the sponsor. and he knows the urgency of it. If our school children need to write entrance exam and they have to go to a law school and all that, he knows this. He has to be here to see to the quorum and all. He has to be here to guide the process, enrich knowledge, and appreciate industry. He's not here. So, Mr. Speaker, it would also be a bad practice to say that at the consideration stage, the law does not specifically mention sponsor. But what the majority chief whip conveniently forgot, and emphasis conveniently forgot, is that in reading a piece of legislation, you don't read them in isolation, disintegrate the law, and give meanings of convenience to the law. The purposive approach to interpretation, as taught us, did not say that read the law in isolation. Mr. Speaker, he and I passed our exam. We passed the exam. We were called to the bar. We were taught how to interpret, how to read the law. Mr. Speaker, if you go to Order 160, Order 160 makes reference to a sponsor. Mr. Speaker, it deals with bills. It talks about the process of introducing the bill and makes reference to sponsor. Once that has been introduced, there is no need to again mention it in 169, because there's a fundamental position that has already been taken. Mentioning a sponsor at 160 is fundamental. Mr. Speaker, if the chief whip wants to litigate, there will be litigation. But if you would follow the path that you have introduced, we will make progress. Go and bring your Attorney General.
Honorable Minority Leader, I beg to differ. I indicated that Parliament is a place of record. Whatever we do is recorded by the Hansard. And for you and I, with our position, we need to adhere to the law. Order 160 that we refer to reads, a sponsor may submit a bill to Parliament without publication in the Gazette, where the sponsor of the bill considers the bill to be of an urgent nature. Until a bill is introduced in Parliament, it's not the business of the House. So it's the business of that sponsor. But as soon as the bill is introduced in Parliament, then Parliament is now seized with the jurisdiction to deal with the bill. So before the introduction of the bill, the rules could not refer to any other person but the sponsor. So rightly, in Order 160, the use of the sponsor is right. But that does not suggest that after the introduction of the bill, particularly at consideration stage, the sponsor must be present at the time that the bill is being considered. So I ask myself, in the 8th Parliament, what happened before I was moving amendment to pass laws in the interest of Mother Ghana, in the absence of the ministers, the chairman, the vice chairman of the committee. So it's the same law that we are making in the interest of Mother Ghana. So with the same spirit, we can really get a member from the minority to be proposing the amendments.
Mr. Speaker, you are right that at the consideration stage, there is no mention of the sponsor. But Mr. Speaker, what I did was to invoke the rule of prudence. That I invoke the rule of prudence. Prudence. Mr. Speaker, is one of the rules in equity. It's part of, Mr. Speaker, is one of the rules of equity. And you invoke them in a parliamentary jurisprudence, the nature of which we find ourselves, to argue that it will be prudent to have the Attorney General in the chamber to guide and shepherd the process, although 169 does not expressly provide for same. Mr. Speaker, procedure and prudence, when they clash, procedure give way to prudence, and we know this. So I agree that though procedurally there is no such provision, I agree, and I'm not going to contest that when my very learned senior, the first deputy speaker, has made that clear. I'm not going to contest that. However, some other overriding rules overreach that, and that I submit that to the extent that we can argue prudence, the non-availability of express provision can be overreached by invoking prudence, because it is the Attorney General, it is the Attorney General's responsibility to be in this chamber Mr. Speaker. The Attorney General has a duty bona fide to be in this chamber in respect of this bill. The Chief Whip himself says that the Attorney General was called. He does not tell us what the Attorney General is doing outside of this Parliament, or what is preventing the AG from coming here, whether he's holding a press conference or doing something somewhere, we don't know.
Honorable Minority Leader.
Mr. Speaker, I would rest my case.
Yes. But Mr. I also want us to
yes, Mr.
look
Speaker,
at the argument in line with Article 93(2).
Very well.
Which vests the legislative power in Parliament, but not in any minister. Yes, 93(2). I can read. Subject to the provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. It never vested the legislative power in any minister, but it is vested in Parliament, and this is Parliament to do consideration of a bill. So no jurisprudence can oust this power. So we should be careful not to place our legislative power to make law at the instance of any minister. It would have been a very bad precedent. So, honourable members, the legal education, yes.
Mr. Speaker, I will plead with you, Mr. Speaker, I will plead with you, let us have just 5 minutes suspension and consult, please. No, Mr. Speaker, it's for a good reason. Just 5 minutes suspension, not more. Let's engage and come back. 5 minutes suspension.
Honourable members, if the leaders want to engage, I have no option. So I will grant exactly 5 minutes suspension to enable the leaders engage. Is accordingly suspended for 5 minutes.